Okay, good afternoon, everybody. This is a meeting of the House Criminal Law Subcommittee. We have three bills on the docket for today. We are going to start with House Bill 437, and then we're going to return to House Bill 21, and we'll end with House Bill 259. I should warn everyone that our committee council has a hard stop at 3, so we will hopefully wrap by then. So let's go ahead and kick off with House Bill 437. This was the visual surveillance with prurient intent, and the bill was intending to add the word residence into a list of places with an expectation of privacy. And Delegate Crutchfield, I believe you have an amendment to the additional C2 portion of the law. Is that
Yeah,
ready?
yeah, there's an amendment. And in fact, I raised it last week, and that's the only amendment I have, which is to just define it a little bit more, the residents. Hold on for a second.
Do you have an amendment number, or rather, did you email this to
Yes, I sent it to Daniel last week, and I also sent it this week.
okay.
That is the amendment. Yes.
All right, Chris, do you want to scroll to the relevant portion? All right, let's keep going. Okay.
Their question. I'm sorry.
Yeah, is there any discussion on this amendment?
I'm sorry, but I don't see well. So where specifically is Charlotte's amendment? Is it the black or what is
It
it?
is line 13 and 14 of what we see here.
Mhm.
Okay,
Um, this
can
is
you
changing
It's changing it from regardless of whether it's an individual in a public or private place to just the locations of the individual.
and what was your thought process on that? Just so I can understand it.
Yeah, and then there's if you go up to the modification section, I'm not sure if um State's Attorney Feinstein is on here yet because she has more of the detail on it because this is an amendment from
Mr. McCarthy's office.
no, this is an amendment that was accepted by JPR. So she should be on here soon.
Delegate Crutchfield, can you just
Yes.
explain like the idea? So is the idea to narrow it a little bit? Is that
Yes,
the concept?
the idea is to with the residents, keeping it at residence, it was very narrow, and now to actually open it up to other locations where individual would be, where there would be prudent intent to actually survey them.
So if I am, say, in a, I guess I'm trying to think where in the back room of a convenience store because I needed to change, and the guy at the convenience store gave me the ability. I guess is that. I'm trying to think of. Give me an example.
Okay, using your example, the back room of a convenience store where there is surveillance video, but and the person has the intent to use it in a sexual nature. Yes.
Uh-huh.
and Chris, can you scroll back down to the other portion? Yeah, here we go.
So the prurient intent is regardless, it always has to be shown.
Yes, that intent has to be there. Correct. So a ring camera, something like that, doesn't have that intent. Okay. But if the person has the intent of using it in some kind of sexual nature, then yes. And it looks like
that has to be proven by a preponderance or by clear and convincing or
good
beyond a
question.
reasonable doubt.
Good question. And since I don't
Hold on.
litigate,
Claire's got her hand up.
yeah.
Well, just to address that last bit, this is a criminal,
Right.
this is a crime, so it would have to be beyond a reasonable doubt.
Beyond a
Every
reasonable doubt.
element. But what I was raising my hand to say is that in this, what we're looking at, the line 13 and 14 change, to change that to say the location of the individual, what that does is it clears up one of either the main or one of the purposes for the bill was to make this apply to a residence, like that hunting cabin incident a few years ago with the former judge. So under current law, where it says this could not be used in a residence because where it says regardless of whether the individual's in a public or private place, a residence is not a public place, obviously, and then also it was not part of the definition of a private place. So a residence was neither a public or a private place. So this, tweak in the language just clears that up, clears that problem up.
Okay, that makes sense. Scott Schellenberger's got his hand up. Go ahead.
Right, and to answer Delegate Cardin's question, if the employees regularly disrobe or change their clothes in the back of that store, in the back room, then there was an intent that that be a private place. So I think that's how that would apply in the case that Delegate Cardin gave.
Okay.
Like if people regularly change their clothes back there.
Right. But and to get the evidence in, is the beyond a reasonable doubt still the standard? Or is it like for a pretrial hearing, would it be a different standard? Or is it always beyond a reasonable doubt?
No, I would consider it an element of the offense, and therefore I must prove it beyond a reasonable doubt.
Okay.
So I think I would have to put on like 3 or 4 people to say, oh, everybody changed back there and everybody knew it. And we didn't know there was a camera back there.
Right.
All right. You got Tamara Stofa's hand up.
Hi, Tamara Stofa with the Public Defender's Office. In the example that everyone was referring to with the judge recording, that happened in a restroom, in a bathroom, which is already covered by the statute. Allowing the residence to remain is still very broad, not narrow as what was indicated previously. And so for that reason, I don't think that the amendment at this is appropriate because we do have a restroom that it's covered already in the statute.
So can I then ask the public defender question, Mr. Delegate Moon?
Sure, go ahead, and then we'll go to Delegate Bartlett and then Debbie Feinstein.
Okay, so if in that example, Madam Public Defender, if it wasn't in the bathroom, but rather was in the living room, but it was just the two of them, or just the guy, the kid there, so you're saying that there shouldn't be protections for that individual at that point?
If I'm understanding your scenario correctly, you're saying that both in this allegation, it would be a defendant and a child that were both in the public living room together, and then let's say the defendant was not in the living room; he was in the bedroom. Okay. Checking out his camera, where the other individual, whether he's a minor or not, thought he was private because he told him, "Oh yeah, you can use this area to change, and there's no one else here except for you." So you're telling me that regardless of whether it's a living room or a bathroom, or it shouldn't make a difference whether it's a living room or a bathroom, even if he had a reasonable expectation of privacy? Is that think what I'm indicating is that there's a real risk when you leave the word residence in there, that it encompasses many scenarios. And I just wanted to clarify the factual scenario of that
Fair enough.
unfortunate circumstance that occurred, and that that scenario would have been covered because the restroom is already covered in this particular statute.
Okay. Delegate Bartlett.
Thank you, Mr. Chair. So I just want to make sure that, and actually, this is a question for Debbie Feinstein since she's going to be next. So wherever I am, and I love regardless of the location of the individual, because the key is to protect the person who is being recorded or photographed without their consent, protect their private areas. So for instance, if I am at a bar and it's a public place, but there is someone who is taking, I won't even say myself, I say somebody is at a bar and they're taking pictures of this woman who's sitting at a bar and she has on a very short skirt. And or maybe they even have cameras underneath the bar stool area. And unbeknownst to her. It's not something that the public would normally know, or maybe this is just one person who's doing this. So my point is that it doesn't matter. It's not the location. I thought that was the whole point of this change in the bill, is that it's not the location that we're going to concern ourselves with as much as it is the fact that someone has a camera and they're taking pictures of a private area of an individual without that individual's consent. And that's how I read it to be. So I just wanted to check and see if Ms. Feinstein could clarify that for me.
Right, Ms. Feinstein.
Thank you, Delegate Moon. So just to clarify on that point, it's really, it's wherever the person would reasonably believe that that their private area would not be visible to the public. So it's not only the individual, it's their private area. So it's
Right.
where a reasonable person would believe that it would not be visible to the public. So actually in the example you gave with the cameras under the bar, I've never heard that one before. That's really interesting because there's actually case law in child exploitation around upskirting, which is what that is, taking photos up the legs. I think that people wouldn't expect that there are cameras underneath the bar that are specifically recording up someone's skirt. Now, I mean, I think that's an unusual example. I think the more likely example, and the reason that we need the change in this bill is the examples that the example that I gave when I testified earlier, which is the person in the private home, in the bathroom in the private home. Now, does that person have the same expectation of privacy in the living room? And would this be a place where they would believe that the private individual of themselves would not be visible? Well, if they're walking naked in the living room and that's not something that they usually did, well, I don't know that we could make that argument. If they were often naked in the living room and the roommate knew that and set up cameras specifically to record her being naked in the living room, and then it's a different situation. I mean, I think it's going to be very situation specific. I think the reason that the language needs to be changed in C2 is because of the situation we ran into in court, which is the court said, regardless of whether the individual is in a public or private place, and then use the definition of private place that did not include residence. And so that's why that didn't work out either, if that makes sense. We weren't able to, the judge acquitted under both sections in the trial that we had. So I think that the critical part is changing and adding to the definition of private place residence. Appreciating what the public defender is saying, what Mustafa is saying, but again, it's still going to have to be that they had a reasonable expectation of privacy in their own, in their own private parts, if you will. I mean, that's what the statute says.
Okay. And I'll just say, I'm personally satisfied with the prurient intent requirement in here. Do I have a motion on the amendment
I so move.
Second.
Second,
All right, all in favor of this amendment, raise your hand or say aye.
Aye.
I think
aye.
I
Aye.
thought Delegate Embry had a question before we did the vote. Okay,
Oh,
no, she didn't.
Okay. Is there anyone that wants to be recorded in the negative on the amendment? Okay, and Delegate Simmons, I assume your hand is just still up from before.
Yeah, I apologize.
No problem. All right, do I have a motion on the bill as amended?
I
Move
move
bill as
favorable,
amended.
Mr. Chair.
Second.
All right, all in favor of the bill as amended, raise your hand or say aye.
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 Does anyone want to be recorded in the no? Doesn't look like it. Okay, thank you, Delegate Crutchfield. We are going to move
Thank
on
you.
back to House Bill 21. This was the bill regarding the district commissioner charging process. And I think we had consensus around some of the smaller amendments. And so if before we get back to the meat of the bill, I would actually like to see if we can move through the amendments that I think are simpler.
Mr. Chair, it looks like Delegate Aircan has her hand up.
Delegate Erican.
Yeah, whenever you get to amendments, I have an amendment to offer on behalf of a colleague who's not here right now. So just let me know whenever you're ready for that.
Okay. Sure. So I believe we had, and Chris, maybe you have, you can put up on the amendment on the screen the amendments that I think we are in agreement with. All right, so this is simply stating restating the penalty of perjury that's on the application. And you want to keep scrolling down. Right. So this is a effort to get at Delegate Embry's suggestion that we do immediate notification that one of these commissioner charges is coming. And then we add some language here about restitution in addition to whatever other penalty is there, so that it raises the specter of someone specifically getting their attorney's fees or what have you back. And I think we had a 1 year. Did we mess with the 1 year in this one? Can you scroll back up? Oh, sorry. And that's, oh, sorry, that that actually, yeah. So the 1 year, I've omitted the 1 year change there. And then scrolling back down, we've got the shielding discussion from yesterday here. So all of those before we get to the discussion about crimes of violence, sex assault, and domestically related cases. Does anyone have any discussion on what you just saw here? Again, which is what I think was a consensus bit from last week's discussion. Delegate Embry and then Brian Levy.
Thank you. I agree with everything. And the last amendment, the shielding, instead of summons, I think we should say charges, or because we don't want to exclude the cases involving a warrant. In fact, we might, those are the focus of the bill. I would say of charges issued.
A case arising out of charges issued by a district court commissioner. Well, I'll say we can entertain that alteration unless anyone has any objections. So if you do, raise your hand and get in the queue. Let's go on to Brian Levy. Brian Levy from OPD. Are you frozen? You might be frozen. All right, let's move on to Delegate Erican.
Thanks. Can we just scroll up a little bit? I just want to see the language again from some of the, okay, I like that part, like the 1 year. Is there anything north of that okay, what's that piece?
That's so that there's immediate, well, attempts to be very quick to notify the state's attorney
Okay,
that one of these cases is been requested, essentially.
okay. All right. And is there anything farther north than that, or is that okay? Okay, what's the,
That's restating the penalty of perjury
okay,
that's already on the form.
involved by the application. Let's scroll down a little. What's that? What's 3I2? Is it, oh, this is if they're a police officer.
Yes.
So, okay, so this isn't the citizen complaint piece. This is just if it's a police officer.
Claire, is this new language in this this line 28 bit here?
That's the part of the bill that we haven't really gotten to yet. That's
Okay, that's on the bill as introduced.
yes.
Okay, cool. All right, thanks. I think I'm comfortable with all the changes that you guys have figured out.
So at the moment, it would be everything that's here, minus the meat of the bill. So all the things I just enumerated with Delegate Embry's modification that we change the word summons to charges. All right,
Move the amendment,
Hassan,
Mr. Chair. Oh, sorry, Hassan has to go. Yeah.
let's hear from Hassan and then Carrie Crumbaugh-Love.
Well, I think we agree with Delegate Emery. So I think we got to wait until after we have this conversation about the meat of it, because the intent of the bill is to ensure that the district court commissioners have absolutely no right to issue any warrants. So if it stays that way, and if it's all summonses, then that language as currently written would work. But if it is changed with any exceptions, then I agree wholeheartedly with Delegate Emery's suggestion that the summons be changed to charges, because if there is somebody who is issued a warrant, that would no longer be relevant to them, and that means that shielding wouldn't apply to them. So let's, I think after
that makes sense. So we'll do a straw poll on this bit, and then we'll do a straw poll on the next bit so that we can see how both of these align. All right, Carrie Crumbaugh-Love.
Hi, I was looking at section 5 where, and maybe this is going to be discussed after the meet. So I just wanted to note that at least as written, section 5 makes no sense, because right now as written, it says the commissioner may only issue an arrest warrant if the individual filing the application is a police officer or a state's attorney. But then you go down and it says immediately after issuing an arrest warrant based on an application for a statement of charges filed by a person other than law enforcement or the state's attorney, the district court commissioner shall forward the arrest warrant. So they're saying two different things is the point. So, right. Does that make sense?
Yes. I wonder if here it should say summons. Claire?
We will conform this
Yes.
these amendments to whatever is decided for the, as Delegate Moon says, the meat of the bill,
Right.
guts of the bill. Will certainly conform this. This was just my attempt to reflect everything that was agreed on at the last meeting. So if it's decided, yeah, we're not going to let commissioners issue an arrest warrant based on an application for a statement of charges filed by a citizen at all, then this will come out.
Okay, makes
that
a
was
lot of
it.
sense. So
Thank you.
that's a set of questions. Thank you, Claire. Okay, so it sounds like we're basically in agreement on this part. Now, if we could go back to the amendments we were looking at last week, that attempted to strike crimes of violence, sex crimes, and domestically related cases from the bill. I will tell you, since we last left the conversation, the state's attorneys have reached out to suggest that on the and some, they're here, so perhaps I should let them speak for themselves. But as I understand it, that on the basis of the conversation last week, they have decided on this meat of the bill to push for the bill as introduced, which did not have the exclusions you see on the screen. So that is the current state of the discussion. We were, in consensus building mode. We were attempting to, narrow out all the things that might give anyone discomfort. And it is now the request of the state's attorneys that we revert the bill as this might seemingly narrow too far. So I will. Why don't we turn it to the state's attorneys to reflect their position here? And I guess among them, I will ask: is there someone that's sort of speaking for the group on this account?
I'm happy to speak for the association.
Okay.
I see State's Attorney Schellenberger is here, and also my colleague, Mr. Giordano from the city. Basically, so the State's Attorneys Association, historically on bills like this, has been concerned about victim access to the commissioner process in a way that can afford the commissioner an opportunity to issue arrest warrant in urgent and sort of life-threatening situations. And in the State's Attorneys Association's estimation, that would really be crimes of violence, sexual crimes, and to an extent, domestically related crimes. But as we've sort of engaged in this process, as we've thought about this as an association, as we've participated in the subcommittee meetings last week, we sort of went back and we've had an opportunity to revisit our position, to think about the points that were raised by the public defender's office, by the other advocates that were on that call, and to really also look at our numbers and see exactly sort of the impact that these amendments and the bill as drafted would have on sort of the practical case sort of volume that we see. And what I can represent to the committee is, at least in Wicomico County, we had a little bit less than 500 civilian-initiated charging documents in 2024. 31 of those would have fit under A and B. And of those 31, almost 27 of them were either dismissed in their entirety or the felonies were dismissed and we proceeded on the misdemeanors. These cases tend to be extraordinarily difficult to prove, and that's assuming that they are, indeed non-frivolous. A lot of them, anecdotally speaking, tend to be. And that's sort of the generous estimation. I think Mr. Giordano can explain the concern that animated this from the city, is that they were seeing individuals using the commissioner complaint system as a cudgel, as a weapon to sort of go after individuals that they didn't like. They were sort of activating the machinery of the state to accomplish their own private and unlawful objectives. So what we're talking about when we're talking about crimes of violence and sexual crimes is an extremely small number of cases. And it's an extremely small number of cases that are, for the most part, either frivolous or impossible to establish beyond a reasonable doubt. If we look at domestically related crimes, and I'm still sort of trying to pull these numbers so I can get a better idea, but at least on the set of numbers I've seen, roughly half of the warrants issued on misdemeanor civilian-initiated complaints were for domestically related complaints, or complaints that would arguably fall under subsection C of the amendment. So like the public defender's office had mentioned at the last committee, their concern last Monday was that this was an exception that would swallow the rule. Based on the numbers we've seen, based on our discussions as an association, I think we completely agree with them. I think that providing this carve out would really defeat the whole purpose of the law. Now, I will say, and there's been some discussion of this today, that this by no means sort of excludes victims of crime from accessing the criminal legal system in its entirety. What this provision does basically is that if there is a warrant to be issued, it needs to be issued at the request of the institutions our communities typically expect to adequately investigate criminal allegations. So an individual who's been a victim of a crime of violence, a sexual crime, a domestically related crime, of any crime, by reporting this to law enforcement, which will give law enforcement an opportunity not just to sort of investigate, but to protect that victim's safety from the jump. We'll still see warrants in those cases. If a victim doesn't want to report their concern to law enforcement or to the state's attorney's office, they can go directly to the commissioner's office. And there will be, if a commissioner finds probable cause, a criminal charging document issued. So this will still initiate the criminal process. There will still be a case. It's going to get docketed. It's going to be reviewed by our office, and then we'll probably send it to law enforcement to conduct an investigation. And there can still be warrants issued on these types of cases. It just requires the involvement of the police or the state's attorney. And so ultimately, after participating in the committee discussion, after listening to other points of view, and after really sort of spending a lot of time and thinking about this as an association, the Maryland State's Attorneys Association has decided that really our initial thought that favorable with amendment really sort of is not where we wanted to be as an association. Right now, the association supports the bill as introduced without the amendment that we currently see on the screen.
All right, let's go to Scott Schellenberger and then Delegate Erican and then Lori Ruth.
So I agree with the concept of the crime of violence and the sexual crimes. After my conversation last week with State's Attorney Ivan Bates, I did not realize the extent of the problem in certain jurisdictions. However, I still think we need a carve out for domestically related crimes. They're very often so dangerous that we have to act quickly, and sometimes the victim doesn't go to the police, particularly if the person who they're charging has law enforcement relationships. The other thing that I think will help is the section you already added. That means a commissioner's got to send this to us right away so that we can make a decision. And, if, as Patrick explained, if I get it and I look at it and I start saying, whoa, wait a minute, I can immediately have the police investigate it and we can take quicker action. But I still think and I must say I'm in the minority. I lost my argument. I'm in the minority. I agree with taking out A and B, crimes of violence and sexual crimes. I still think we need a carve out for C. I think we need that added protection for domestic violence cases.
All right, Delegate Erican, and then Lori Ruth and Lisa Jordan, and then let's try and pause for a second. Go ahead.
Thank you, Mr. Chair. So yeah, as State's Attorney Schellenberger mentioned, I'm really uncomfortable with the piece that with moving it as a clean bill. I don't know how. I mean, the domestic abuse stuff aside, which is really concerning, and like he said, it's already really hard for people to come forward. None of us come forward. There is a reason why no one comes forward. It is not comfortable, easy to do. People don't believe you. On and on and on and on and on. If somebody's brave enough to finally come forward, but has a partner, in law enforcement or connected to the state's attorney's office in some way, and some of the smaller counties, we're all connected to each other. It's worse than Baltimore. Everybody knows everybody. So, I mean, I feel really concerned about removing an avenue of access for especially women victims, but really for anybody. So, I mean, the amendment that Delegate Grammer drew up, he's not here. He couldn't be, or otherwise he would be giving it himself, would keep the process intact. I mean, we've already protected, people from having their names put on case search. We're shielding them. We're putting a lot of safety measures in place, a lot of guardrails in place. I do not know how we can justify to the citizens that we're taking away what feels like in Maryland has been a civil right, to a direct access to potential justice. It seems almost unconscionable given the incredibly low rates of disclosure, especially of sexual abuse stuff. It just, no one is coming forward, and limiting any access to it is really scary and disturbing. And I hope we don't go that direction.
All right. And I'm keeping an eye on the clock here. Let's hear from Lori Ruth and Lisa Jordan. If we could keep it super short. And then I actually want to ask a question, but go ahead.
Thank you, Delegate Moon. I'll defer to Lisa on the discussion of the sexual assault, sex crimes, and just talk about the C, crime committed by defendant against a victim who's a person eligible for relief. I agree with Scott Schellenberger. I don't often say that. Sorry, Scott. I think the entire problem with this bill is that you're carving and carving, but not addressing the most serious things that happen. And some of these are extremely dangerous situations that the victim only knows to go to the commissioner and say, he's going to kill me, he has a gun, or the police have dismissed it, or she's gone to her local precinct and they think she's exaggerating, or and the case that happened in Rosedale on Christmas Eve, the police had been there the night before and they said, go get a protective order tomorrow. And that was the morning of Christmas Eve that he murdered his child and shot both her and her other child. And so I really urge you to not pass this bill clean, because I think it's punishing the people most at risk and putting them in more danger. And I'll keep it at that to be short. Thank you.
All right, Lisa Jordan.
Thank you, Mr. Chairman, members of the committee. I echo everything that Scott Schellenberger and Lori Ruth said. I think that the reason that we advocated for so long and for so hard to give commissioners the authority to issue the arrest warrants in the first place was because survivors were not getting good results from the police. They were having police officers, tell people to walk around the block. And maybe that doesn't happen as often as it used to, but they do say, oh, this isn't serious enough for me to arrest someone. You should just go get a protective order all of the time. And it's very important that you have the survivors have access to a commissioner to be able to make an appropriate response in an emergency. As to the sex crimes and the crimes of violence, I will say that if you show up at the commissioner's office and you allege rape, I can think of no more than a handful of cases where the commissioner didn't say, you need to talk to a police officer. We need to use a different technique here. Now, there are cases, including cases that we've had in Baltimore County that Mr. Schellenberger is aware of, where there was a disagreement and the survivor wanted to file an application for statement of charges. And I'm loath to give up the right to at least start that judicial process to a group of survivors who really have not always had a good response. I'd like to say that everything is great now and everyone is having a much more sensitive response to sexual assault and domestic violence and child abuse cases, but that's not actually true. And this is really an important backstop that also really helps protect people. And then I'll also just mention that it's a little surprising to hear all of this change in the State's Attorneys Association today on a subcommittee call. This is not data that we've heard before, and I'd be very curious to have more information from the Special Victims Unit and from others who we usually work very closely with at the State's Attorney's Office. So I really hope that the subcommittee at very least delays making a decision on this.
Okay, and frankly, Delegate Grammer's now texting that his absence is, but he has strong feelings on the bill. So before we have additional commentary on the bill, why don't I just float this as a straw poll first? So again, assuming we take all of the other changes we've talked about, the shielding, the immediate notice to the state's attorneys, and the like, the consensus amendments, and Chris, actually, why don't we keep the text on the screen, the amendment text on the screen? actually. It seems to me that we would, if we kept C but got rid of A and B, we would be substantially moving in the direction of the bill sponsor's intent, and certainly as to complete strangers and the like, we would be narrowing out at least some of the cases for the folks that showed up to testify, but not all of them. I just want to take a quick straw poll on whether the subcommittee could live with that world.
Yeah,
Going with C, but getting rid of A and B.
Yeah, Mr. Chair, I could live with that. This is a Delegate Kaufman.
Is there anyone who would be opposed to us
Me.
moving forward with a bill in that posture?
I'm opposed to it.
Yeah, because wouldn't we be getting rid of abuse? As we'd be getting rid of abuse, right?
Yeah. Crime of violence and sexual crimes. We'd be removing those.
Well, sexual crimes we would keep, but the abuse is in 4-501 of family law. That
Well,
I
that
don't feel
we would
comfortable.
keep. That we would keep.
Oh,
We
okay.
keep-
Well, then
we keep C, but get rid of A and B. So we
Yeah.
get rid of crimes of violence and we get rid of sexual crimes. So only basically if you have already filed for a TRO or something, would you now be
You're
eligible? to-
eligible to.
Yeah. So
Yeah.
it's a very limited scope for people that have already been brave enough to go get that. Now they can have this extra thing, but everybody else is screwed.
So again, let's actually frame it this way. You'll have three options. The bill clean, essentially, without these three restrictions, the bill with these three restrictions, or the bill only with C, domestically related cases removed. Why don't we just go through the shoe, and if members want to quickly just spot where they're at. I mean, clearly we're going to be coming back to this next week, but we'll know which amendment we're debating, which of those three amendments we're debating for a final vote next week. So why don't we just go in order? If Delegate Ember, your hand's up and you're first on
Yeah,
me.
this is relevant to how I feel. Today is the first day we're hearing data about how many warrants are issued in these categories and what happens to them. That's all knowable. So it just frustrates me a little bit that we're making decisions about these categories when we could know how many across the state, how many of these charges are issued and whether they are, what percentage are dismissed or pled down to misdemeanors. So I just would implore the state's attorneys who feel strongly, who are on this call, if before next week you could actually give us a breakdown, that would help me in my decision making. Thank you. But I don't know if you're asking me my vote right now. I'm torn between supporting the bill with only C or with A, B, and C.
All right, Delegate Kaufman, and then Delegate Cardin.
Well, I would say that this is not my area of expertise, but I tend to trust the state's attorneys. So if it ends up being B and C, like Delegate Embry said, I'd vote for it, but I'm fine with it clean at this time.
All right, Delegate Cardin, and then Delegate Boucher, and then Sample Hughes.
Thank
You guys
you.
aren't sure, you can
Mr.
say you
Chair.
don't know.
Just, Mr. Chair, I would actually, I'm similar to Aaron, to Delegate Kaufman, but I would say the state's attorneys came and I trust them. I would go with it clean. I am open to talking about this with them, but and whether we want that third amendment of just having C, but I would prefer to just get it out clean and we can continue to discuss later.
Delegate Boucher, Delegate Sample Hughes, Delegate Bartlett.
Thanks, Chair. I take this bill to heart because I went through a divorce with a diagnosed sociopath. She charged me over 24 times. She charged my mother. She charged witnesses. This was used as a witness intimidation tool. So I'd like to see the bill pass completely clean with no A, B, or C, but I would settle for keeping C if we have to, because I think State's Attorney Gilbert made a good point. These charges would be sent to the state's attorney and the police to investigate. It wouldn't be the end of it by removing A, B, or C, but it would put it into a different process to properly be vetted and combed through, because this is a tremendous weapon of intimidation in divorces. And I'm sure a lot of the lawyers out there and the state's attorneys and the public defenders, they see this weaponized. And this is something I brought to Chair Clippinger's attention as soon as I was elected and went into his office to discuss with them. This is ripe for reform, so I really like to see it reformed clean, or at least see. Thank you.
Okay, Delegate Sample Hughes and Delegate Bartlett.
Thank you, Mr. Chair. I guess I'm torn between some of the new information and trying to process what we went through on last week. So I'm good with the clean version. Not so much on C. And I don't know if I'm prepared actually ready to vote at this moment. My apologies for that, but that's where I'm in the process.
Not a problem. All right, Delegate Bartlett, you'll have the final word on this, and then we'll do a very quick spin on the last bill.
Okay. I'm not prepared because I don't completely understand what A, B, and C does with respect to number 2, where it says the individual filing the application is a police officer if no charge in the case is. So I don't understand what this amendment would do. I definitely don't like whenever I see, sexual crime and abuse crimes. These are things that obviously are right in my wheelhouse that are important to me. So I don't understand what these carve-outs are doing. And if I could just get an understanding of that, I'd be in a better position, although not quite ready to vote yet. What do they do? If we say this, what are we doing?
That a citizen can't go and get a warrant.
Contact with you.
Their word.
Yeah, couldn't bring my radio with me.
Unless
I went in, made the rescue.
For a crime of violence or a sex crime.
Please mute if you're not talking.
The person, the only exception to that would be we're carving this out if it's a domestically related case, essentially.
Okay, so we're saying that
so strangers. So if I go and some of the cases we heard are third party disputes, total stranger, never met in person, or two people get into some sort of bumping fight that they don't have any romantic or relationship like that whatsoever. Some of those cases I think would come out under what we're doing. If we just do C, some of those cases would come out.
Okay, and so it sounds to me that what we're doing is placing high. Are we putting essentially when someone comes into the commissioner, are we putting their claims kind of in a hold? What would happen to someone's claim when they come in and they have a crime of violence or sexual assault claim?
Charges could be issued through a summons.
Okay. All right.
So the charges could still be issued, or the commissioner could say, I'll issue a summons, but I encourage you to go to the police. Which is why the only thing I worry about is the domestic violence. That's why C, I think, should stay in. I'm sorry, Delegate Moon, I'll stop.
No, you're good. All right, and let's actually stop there so we can have 5 minutes.
Delegate Moon, I'm sorry. This is Ivan Bates, State's Attorney. This is my bill. Can I say something, please?
Yes, please. Well, a couple minutes. 1 minute.
Yes, thank you. First of all, Scott Schellenberger doesn't speak for me or the State's Attorneys Association. We had this conversation, and I'm a little shocked that Scott is still speaking, number one. Number two, I understand where
Ivan, I told them that I was in the minority.
That's okay.
I told them I was in the minority.
I understand where everybody's coming from. I get it. I understand. Our issue is that we have had a number of individuals that have used the commissioner's office as a weapon to have people arrested. And when they get angry, then before you know it, they're no longer angry. They don't come to court. So that's very unfair. However, when it comes to number C, I also understand the need to protect true individuals and true victims, true without a doubt. I think last week you did have a sort of a compromise where you said within 75 hours or so many hours, the state's attorney's office would investigate. If we didn't have information or evidence, then we would be able to dismiss the charges to allow this individual out of jail. I think there's a compromise there. I just wanted everybody to understand the reason why we're so in need of this, especially in Baltimore City. This charge has been used, and matter of fact, even today we had an issue where the commissioner wanted to charge individuals additional charges, and they don't really understand what's going on, and now people are sitting in jail. That is the issue, and that is the concern that we have, and we want to make sure the commissioner doesn't have the right to just do this whenever they want to. It has to be a prosecutor, someone with a law degree who deals with this type of law to understand what's going on. That's all I wanted to say. I'm sorry for interrupting, but I did want to say that being the bill sponsor. This is really the only bill that we're looking at from Baltimore City because this has become such a horrific problem. I'll try to have some additional material next week. Thank you.
Okay, and colleagues, just to sum up, it sounds like we're between the crime list being out and having a clean bill on that respect, or keeping C in is what it sounds like the subcommittee consensus is. But we'll be back on that A or B next week. And let's see, can we just have 3 minutes on the last bill? This is the DNA collection bill that I believe we passed a version of last week, or excuse me, last session. But I see that the Senate has amended it. So if we have someone from MSP who wants to quickly explain, refresh us on the bill and what the Senate has done, we can have 2 minutes on that.
Good afternoon, sir. Catherine Kelly, Maryland State Police. House Bill 259, as you have it in front of you today, is in fact the very same bill that you passed last year out of committee, and the House passed it as well. The Senate did not move the bill last year. It hung up through sine die. This year, the Senate undertook the bill and made 3 amendments. 2 of the amendments are more descriptive as to who would make the probable cause determination, and we are fine with those amendments. And the last amendment changed the $10,000 penalty to $1,000. We are also fine with that amendment, sir.
Okay, there was some language in one of the amendments that touched on the commissioner charging process. Do you have an indication of what that language is intended to be?
The language that it actually divorces the citizens' complaints from a commissioner issuing a warrant without a law enforcement or a state attorney bringing the information to the commissioner.
In other words, that was attempting to exclude the commissioner cases from the scope of the bill.
No, to exclude the citizen complaints that go directly to a commissioner.
Got it. Okay.
And of our 16,279 cases, that will not change the majority of the limbo cases. That is negligible.
Okay, got it. Tamara Stofa, is your hand up for this bill? You're on mute.
No, thank you. It was up for the previous one. Thank you.
Okay. All right. So it sounds like the state police are in agreement with the amendments the Senate put on.
Yes, sir.
All right. So when we return next week, we will be back with that bill and considering the Senate amendments and hopefully final resolution on House Bill 21. Thank you, everyone, for your attention.